Hello, scholars. This is Mr. Myers. We're going to do lesson 3.8, Property and Privacy Rights. Make sure you take good structured notes over the objectives. We'll start by talking about property and eminent domain, and then move on to privacy rights and then landmark cases associated with privacy. We'll end by talking about what is next on the horizon regarding privacy rights in the United States. It's also worth mentioning before we start that I've largely lumped these two groups of rights, privacy rights and property rights, together for convenience sake. There is some loose connection between the two, but largely it was just easier to kind of do it that way. So, in terms of property rights, we would say that our right to property is an inherent natural right. It goes back to the Enlightenment when John Locke articulated that all men are born with natural rights, and among these are life, liberty, and property. Right? Thomas Jefferson took that line and obviously changed it to life, liberty, and the pursuit of happiness in the Declaration of Independence. But the idea is that all men are born with this natural right. Now, there are limits on property ownership that exist. There are two important ones. The first are local ordinances. You might have zoning laws in your city or in your area that prevent you from, say, like pouring a concrete pad in your front yard in order to store your RV. Or there might be other limitations on what you can do to your property. For example, you might not be able to run a business out of your property, depending on the zoning laws in your local ordinances. You might also have subdivision rules that you have to follow if you're a part of a subdivision. So, a homeowners association might, for example, say that the only flag that you can fly is an American flag, or put limits on the kinds of signs that you put in your front yard, or whatever the case might be. The other limit on property ownership is the concept of eminent domain, and that can be much more significant. Eminent domain refers to the basic idea that the government can confiscate your property or buy your property if it has some kind of greater good attached to it. So there might be some major public works project, like a highway or something along those lines, that needs to be built, and there might be homes in the way. The government could come in, and as long as they provide fair market value for the homes, as long as they compensate you fairly, it is legal for the government to confiscate or to take that property. Now, there's some issues associated with that. You can see on the right that it's somewhat subjective about what constitutes the greater good. I think most of us could understand the basic idea of a highway that all people could use, that could benefit and speed of travel for everyone. But what about taking private homes to build some kind of development, like the Promenade in Brentwood, or a casino or a stadium or something like that, that would only benefit a more narrow constituency. It's also important to mention that historically, when eminent domain has been applied to large projects like this, it usually doesn't involve raising or leveling rich neighborhoods, right? It just so happens that oftentimes it's poorer neighborhoods, which tend to be more racially diverse, people of color, that often are negatively impacted by eminent domain. Since due process needs to be followed at all times, it's not uncommon for the courts to be involved if people feel like their due process rights have been violated or that they have been discriminated against in some kind of way, shape, or form. They can certainly end up in court. Okay, so on to privacy rights. So there is no explicit right to privacy embedded in the US Constitution. There are multiple places where it's alluded to and discussed. Certainly in the Bill of Rights, there are certain aspects of privacy that are discussed. In terms of beliefs, that would relate to the First Amendment. In terms of preventing quartering of soldiers in the home, that would be the Third Amendment. Protections against unreasonable searches and seizures in the Fourth Amendment. And then the Ninth Amendment basically says that any rights not explicitly mentioned here are not necessarily denied to the people. And so you could also argue that the Ninth Amendment also has kind of this umbrella concept of privacy protections. A key thing to understand is that the word is never actually mentioned, privacy, in the entire document, nor is it in the Bill of Rights. The Supreme Court has referred to a penumbra of privacy rights embedded in the Bill of Rights and other places in the Constitution. This kind of means almost like, shadow rights that are kind of sort of like alluded to, that are implied, but not necessarily enumerated or explicitly mentioned. So there are kind of two schools of thought in terms of interpreting privacy rights then. One would be a broad interpretation that basically says that the 14th Amendment, the Ninth Amendment, and the other amendments that I had mentioned previously pretty much means that all Americans are deserving of some kind of basic expectation of privacy. There's a more narrow school of thought that basically says because it's not explicitly mentioned, no right to privacy exists. Historically, the broad interpretation has won out. More recently, the narrow one has kind of come to the forefront of things. We'll talk more about that when we talk about abortion. Okay, now on to a few landmark cases related to privacy rights that I want you to know. The first is Griswold v. Connecticut of 1965. This is a very significant decision which basically said that people have the right to contraceptives because of inherent right to privacy that was implied in the 14th Amendment. This was furthered in Stanley v. Georgia in 1969 when basically the court ruled that individuals are allowed to view pornography within the private confines of their homes. You can read a little excerpt from Justice Thurgood Marshall on the right from that case, which kind of summarizes the thinking there. So the next three cases we're going to talk about all deal with abortion rights. I'm sure that all of you remember from sophomore year discussing Roe v. Wade. This was a landmark case from 1972, which basically said that the state can't deny the right of an abortion to a woman in the first trimester. It did allow for more regulations and restrictions as the pregnancy progressed through the second and the third trimester. And this was kind of the settled law of the land for a long period of time. Now, in Planned Parenthood v. Casey in 1993, the court went further towards, potentially restricting abortion access when it said that states could regulate and ban abortion after viability as opposed to a trimester system. Viability refers to when the baby might be able to survive outside of the womb on its own, as opposed to, how many months pregnant the woman is. And went further by saying that other restrictions could be imposed on people seeking an abortion as long as they don't impose an undue burden on the mother. Well, that language is very, very, very subjective. Some people would say, okay, well, a 72-hour waiting period could be put in place then. Other people said that a woman would have to have a vaginal ultrasound so that they were forced to hear the heartbeat of the baby before terminating pregnancy. So it introduced all kinds of potential state restrictions into the mix that were subject to court interpretation. Now those restrictions that might or might not impose an undue burden are all moot because the right to an abortion has been overturned. So in Dobbs v. Jackson's Women Health Organization in 2022, the Supreme Court basically upended decades of precedent with Roe v. Wade and basically said there is no inherent right to privacy embedded in the 14th Amendment, and therefore that there is no constitutional protection for women when it comes to abortion rights. He basically said that the only unenumerated liberty rights, the only rights related to liberty that aren't written down that exist in the Constitution are those that are, quote, deeply rooted in the nation's history and tradition, which is somewhat problematic, and I'll talk about that in a minute. What this basically does is refer the issue of abortion back to the states. There is no federal protection for abortion anymore, and now states are left to kind of regulate it. On the right, you'll see a quote from Samuel Alito, who wrote the majority opinion about what he feels is the democratization of the issue now that it's been thrown back to the states. So what next? Well, this first slide deals with some of the bigger, kind of, more philosophical kind of issues. One thing to consider is that Dobbs is arguably the first Supreme Court case to formally take back what some consider a fundamental constitutional right. Now, those that are in the pro-life movement, certainly Justice Alito and Clarence Thomas and others would fundamentally reject that idea, but that's certainly the way some people feel. Another issue to consider in Alito's majority opinion is he talks about those unenumerated liberty rights. The only ones that exist are the ones that are deeply rooted in our history, but our history is deeply rooted in racism and in slavery. The only, liberty rights that were enjoyed, back in the day were those for heterosexual white men. So what are the implications then for minority groups with that language? Does that mean that there are extra hurdles that minority groups would have to jump over in order to enjoy the same basic rights that all of us do today? And you also have Clarence Thomas writing a concurrent opinion, which means an agreeing opinion, but for a different reason. His opinion went even further. He said in future cases we should reconsider all of this court's substantive due process precedents, including Griswold v. Connecticut, which guaranteed the right to contraception, and Obergefell v. Hodges, which legalized gay marriage. In other words, what Clarence Thomas is suggesting is, I think that we should reconsider those cases and possibly overturn them. That obviously has massive implications for millions of Americans. Now, on to some more kind of narrow and specific issues. There have been a host of trigger laws that have gone into effect since Roe v. Wade. These were laws that were passed back in the day before Roe was overturned that basically said if Roe is overturned, this law will go into effect. And so several of those have gone into effect. Some states have moved to protect abortion access. So there have been several states that have actually, codified through the legislature, the right to an abortion. Others have failed to restrict it further. There was a ballot initiative in Kansas that failed to restrict access further, but other states have significantly restricted access, including several that have absolutely no exceptions for rape and incest. You can see a graphic on the right that shows you the status of abortion bans in the United States in that map there. You also see a headline about a news story of an Ohio girl who was 10 years old who was raped and got pregnant and had to cross state lines to Indiana in order to access an abortion. Stories like that have increasingly started to kind of dot the headlines. Conservatives would argue that those cases are few and far between and kind of sensationalist in nature. Democrats would largely argue that only more of those things are going to happen, that this is ultimately going to get worse as opposed to getting better. So, in reading about this topic, I've come to learn that it's likely that the next court battles are going to be about three things. One would be challenging some of the trigger laws that have gone into effect since the overturning of Roe. Another would be issues related to interstate travel. Women who have the money and the means to be able to travel from a state that bans abortion to get one in a state that allows access. There could be court challenges related to that. In addition, there are some pro-life groups who are trying to make drugs like mifepristone unavailable by mail to get around what they would see as a loophole that might allow a woman to bypass, state restrictions on abortion. I hope you took good notes, and if you have any questions, please bring them to class.